Next case will be Audrey Trowell versus Providence Hospital.
Good afternoon. May it please the court. Rhonda Reed Williams on behalf of the appellant. This is a case wherein the plaintiff filed a complaint that sounded in medical malpractice pursuant to the Bryant test. Under Bryant v. Oak Point, which is cited in my brief, there are 3 elements that determine whether or not a case sounds in medical malpractice versus whether or not it sounds in ordinary negligence. The first 2 elements are not at issue in this case. Both parties agree that those elements have been met. Those being a professional relationship and the injury or damage occurring during that professional relationship. The third element, which is at issue here, is whether or not the cause of action raises questions of medical judgment beyond the realm of the common knowledge of an ordinary layperson. In this instance, plaintiff relied heavily on her medical condition to establish her cause of action. She indicated that she suffered an aneurysm that caused a stroke, and she was admitted into the hospital at Providence. Thereafter, the stroke caused cardiac arrest, and she was admitted into the ICU. Thereafter, paragraph 15 of plaintiff's complaint sets forth what she alleges were the violations or failures, the duty, and then the failure to comply with. The first one, and plaintiff indicates in her supplemental brief that defendant did not raise 15A, paragraph 15A, which is a failure to ensure safety. Failure to ensure safety is a strict liability allegation and therefore is not an allegation, is not an enforceable claim at all. And that is pursuant to Bryant at page 425 through 426.
Counsel, good morning. I just have to jump in.
Sure.
And welcome to the court, and it's a pleasure to have you. Where does it require specialized knowledge to know that if you drop somebody twice as you're transporting them, that that's going to cause damage to a person who's had a stroke?
Well, it's not whether or not it's going to cause damage to them. The specialized knowledge in this case comes from the fact that this patient, one, is in the ICU and has certain significant ailments. She suffered an aneurysm, a stroke, and cardiac arrest.
But the injury arose because she was dropped by the person that was carrying her twice.
But the person who is assisting her in transferring has to consider, in order to determine what is the appropriate method, well, first of all, whether or not this patient should even be transferred.
But isn't the appropriate, I mean, isn't this a standard method that's used within hospitals, that when you are lifting somebody, I was in the hospital for 10 weeks, so I'm very familiar with this. The standard approach when you're dealing with a hospital is that when you're being transported to the bathroom or you're being transported to a procedure or whatever it is, there's a standard hospital approach that's used in terms of how you lift somebody, how you transport them. Let's go back a few steps. Number one, is this a nurse? This is not a doctor or a nurse that's doing it, is it?
No, this is a nursing,
nursing assistant,
This
right?
is a nursing assistant.
Like a PCA, a patient care, what's the actual title? Patient care, at Mount Sinai it was patient care associate, so we're talking about a PCA, right?
Well, we're talking about a nurse's aide, and as indicated in one of the cases that plaintiff relies on, Gold versus Sinai Hospital, the distinction between whether or not it's a nurse or a nurse's aide is a distinction without a difference.
Okay.
So, but there is not a standard way to transfer. There are multiple different ways.
How are there multiple?
There are gait belts. There are walkers. There are wheelchairs. There are one person assists. There are two-person assists. So, and the determination
right. So, but the thing is here is that you're talking about basic standard functions that the person is doing. Let me ask you this question. Where is the line on this? Let me just give you a hypothetical. Let's say you're in the hospital and you have food poisoning. The food, it's not part of, you're not on a specific diet, but the food isn't prepared correctly. So you have your hospital dinner, and the hospital dinner was not prepared the way it was supposed to. There was E. coli or whatever it was, and you get violently ill and violently sick because of food poisoning. Would that fall under your theory?
Your Honor, it is going to depend on
food poisoning?
what the patient is in the hospital, what the underlying reason for the patient being in the hospital.
Really? So
because there is case law, and one of the cases I believe
wait. So I'm in the hospital, right? And the diet is not a part of my treatment. I'm having dinner in the hospital, like I did for 10 weeks. You're having dinner in the hospital, right? There's not there's no restriction to your diet. You're just eating in the hospital. Okay. And you're having a meal in the hospital. And you're saying that if you have E. coli that comes, or a staph infection that comes through that food, the way in which it was prepared by the hospital, you're saying that's still that would be still under your theory?
Well, again, what I was suggesting is that there are certain people who are in the hospital and that they have restricted diets because it is a part of their treatment plan.
And I'm asking you, if you don't have a restricted diet and it's just a basic hospital function, you're having dinner, would the hospital then would that be a negligence standard? Or do I still have to use the medical, is that basic negligence at that point?
If the preparation of the food in that instance does not implicate medical judgment, then it does not meet the third prong of the Bryant test. Okay. However, in this instance, you have to look at the reason and the patient's condition. In this instance, there is a different method that one would use to assist someone who, for example, has a spinal cord injury versus someone who merely has a broken foot.
Is that in the script? Is that in the script? Does the team leader give a specific way in which this person is? If I were to go and look at the situation, am I going to find that in the script? The exact way the person's supposed to be transported?
I don't believe that there is actually a script, but that goes to another one of plaintiff's allegations. Again, the training is a part that involves or implicates medical judgment and therefore falls under Bryant as being a medical malpractice action. A layperson, yes, a layperson is going to understand that someone who's sick is at a greater risk of falling. However, determining the impact of the medication that the person is taking.
But a layperson can't understand that dropping somebody twice is going to be problematic.
It's not the act of dropping that is the relevant issue. The relevant issue is the medical judgment that's implicated in exercising the methods by which to assist the person.
Counsel, I don't completely understand your answer. You
Sure.
responded, I think, at least twice to Justice Bernstein by that same formulation. I don't mean to be overly simplistic,
Sure.
but there may be a dozen different ways to carry somebody in a hospital from place A to place B, all of which are at least in part a function of what it is, what the malady is that that patient is suffering from. But I can't imagine any of those dozen ways would be carried out in a proper fashion if it ended up in the process of dropping somebody. Why isn't there kind of a res ipsa loquitur component to this somewhere?
Well, first of all, there's case law that indicates that, for example, dropping a patient when transferring them from a wheelchair onto an examination table is medical malpractice. So it is recognized that dropping someone implicates medical judgment.
At least maybe the first time, depending on the facts. But let me can I step back for a minute?
Sure.
I understand this to be a C7 or 8 or both motion. We have only a complaint, correct?
Correct.
And then your client files a motion to dismiss, correct?
Correct.
With no attachments and no other evidence to help us think about what's alleged in the plaintiff's complaint. Is that right?
Well, exactly. My position
Okay,
was...
thank you. You can stop. Let me just get to my actual
apologize.
question. So I think, you tell me, I think I'm supposed to assume that the allegations as pled in the complaint, which leaves something to be desired, but it is what it is, but I assume those to be true.
Correct.
Right? And I have to consider them in a light most favorable to the plaintiff.
Correct.
Given all of that, why is it crazy for me to think that the second time the patient is dropped might be something that sounds like ordinary negligence?
Because then you're engaging in speculation. Our motion for summary disposition was based on the four corners of plaintiff's complaint. She alleged in her complaint that based upon her medical condition at the time, she required assistance to and from the bathroom. She required transfer to and from the bathroom. That assistance was predicated because of her condition, the medications that she was taking, and then thereby determining the best method to effectuate that transfer has to necessarily implicate her current condition.
Makes sense with respect to the first drop. But then what about that second drop?
Plaintiff does not allege that Dana utilized the same method.
Wait, who's Dana? The nurse?
The nurse. In the complaint,
okay.
She identifies
Sorry,
her as Dana as the
remember
nurse
her name was Dana.
assistant. I apologize, Your
That's
Honor.
all right.
There is no allegation that the same method was utilized. So again,
Maybe there was a different method and it was medically, I see.
what I am suggesting is that plaintiff filed a medical malpractice action alleging that
So this is the method by which to carry somebody who you've just dropped.
Yeah,
Right, that's-
the medical opinion about this.
Exactly, because
Formerly
again,
dropped.
now you've got, now Dana, the nurse's aide, has to consider, okay, the plaintiff has all of these other medical conditions that were going on, and now she's potentially injured as a result of the fall as well. Again, the second attempt to transfer implicates medical judgment. And Your Honors, plaintiff in her supplement introduced,
Maybe the medical malpractice gets worse with each trial, in a way.
well, and so she would have to consider potentially what injury the plaintiff has sustained as a result of the second
You've
fall.
been up for 13 minutes now, but isn't this all about what's alleged in the complaint and the amended complaint?
Well, it's what's alleged in the complaint. The amended complaint was not allowed because the amended complaint basically was the same complaint. Plaintiff just eliminated paragraphs B through D of 15 and left the strict liability allegation in. So that complaint was not allowed. Yes, it's what's contained within the four corners of the complaint. However, what's interesting is that while plaintiff argues that her case was never intended to be a medical malpractice action, in her supplemental brief, she attaches as an exhibit the interrogatories that were sent to defendant. And in those interrogatories makes it very clear that plaintiff was trying to file a medical malpractice action. Why do I say that? Because the first request for production asks for expert reports and opinions. Again, if you require an expert to determine whether or not the standard of care is breached, that necessarily falls under Bryant and implicates medical judgment. The fourth interrogatory asks about medical treatment following the stroke. The 13th interrogatory asks again about expert witnesses. 15 asks about medical malpractice insurance. Why is medical malpractice insurance even applicable if this is not a medical malpractice action? And then again, the 16th asks about notification, placing the defendant on notice regarding possible negligence claims against defendants. Again, the plaintiff was trying to file a medical malpractice action, but once it was revealed that she did not comply with the notice requirement under this medical malpractice statute and the affidavit of merit requirement under the medical malpractice statute, then it was, well, no, this was an ordinary negligence allegation. This was a medical malpractice allegation complaint from the very beginning. Under Bryant, the method to transport a patient depends upon the patient's condition, medical care, and treatment medications, and all of that was implicated in this case.
Well, under Bryant, isn't it essentially, if you think you've got a med mal case, you plead a med mal case. If you think you've got a negligence case, you plead a negligence case. If you're not sure, you're supposed to plead in the alternative. And as I understood your position, is they didn't plead really in the alternative. All they did was plead a med mal case. It's not a med mal case. And the Court of Appeals went too far by saying, maybe it could have been a negligence case. Let's reverse and send it back. Am I oversimplifying or misunderstanding your argument?
No, I think you've got it correct, Your Honor. The Court of Appeals engaged in just bizarre speculation that Dana was answering her cell phone or weighed 90 pounds.
I'm sure Mr. Gonzaga will explain why I'm wrong.
Thank you.
Thank you, Ms. Williams.
How is it that I misunderstand their argument?
No, I said you're right.
I know.
I don't think you misunderstood.
I anticipate he's going to tell me I'm
That
wrong.
you did. I got you. Thank you.
Good afternoon. Mark Ronzato on behalf of the plaintiff appellee. With me at council table are Carla Akins and Jules Olsman, the co-counsel. To the extent there's a self-imposed limitation on the asking of questions, I waive it. This is not a case that you should be involved in. This is a case in which leave should be denied for a number of reasons, the most important of which is the state of the record. I've been involved in a lot of cases in this court, and I've never come across a record that's quite like this. This is a case in which the plaintiff asked for discovery back in October of 2015. That discovery was not forthcoming. The plaintiff also, during the time that the summary disposition motion was in play, also asked to depose Ms. McCorkle, the dropper of Ms. Trowell, and that deposition never took place. The defendant got a certain amount of responses to their interrogatories and requests to admit, but the defendants never took Ms. Trowell's deposition, which meant that...
Isn't this idea strange, the notion that we need more discovery to understand the allegations in the complaint?
Well, that's an interesting question.
It makes me go cross-eyed when
No,
I read that
because,
in a published...
you have to understand...
Hold on.
Okay.
That's in a published Court of Appeals opinion now, right? We have to do more discovery so we can understand what's in the complaint.
Well, that's one way of looking at what's happened here, okay? But you have to understand that the Court of Appeals in this case was really guided, and had to be, by footnote 9 of this Court's decision in Bryant. That's what this case is all about. Footnote 9 of this Court's opinion in Bryant. And the Court of Appeals had no choice. It had to follow, it seems to me, footnote 9 of the Bryant case. Footnote 9 of the Bryant case has two very important concepts in it. Okay? Footnote 9 addressed a case that was a real thorn in at least the plaintiff's side in Bryant, and that was Rogalski. Rogalski was a fall case. I'll distinguish it from a drop case, but it was a fall case in transferring a patient from a wheelchair to an examination table. And there was some hint in Rogalski was merely an order, that perhaps 5838A did in fact define what malpractice was. And Chief Justice Markman had to put in footnote 9 to his opinion in Bryant to explain why the defendant was wrong in relying on Rogalski to say what in fact was malpractice. And footnote 9 has two critically important things. The first thing that is in footnote 9 that's incredibly important here, and it becomes the backbone for 2/3 of the Court of Appeals opinion in this case, is that a fall case, I would consider this case slightly beyond a fall case in that it is a drop case, but a fall case may or may not be professional negligence. That's directly what was said. And 2/3 of the Court of Appeals opinion in this case is, well, what's been alleged based on the scant information that we have here, and it is scant. It's a complaint. We have 20 paragraphs. That's all we have. Ms. Williams tells you that the medical status of the plaintiff is incredibly important here. The medical status, she told you that at the beginning of her argument. We don't know anything about the medical status of the plaintiff. Nothing. Other than that, she had a stroke. That's all we know. What was Ms. Trowell's status? I'll get back to that in a second. Because the second important part of footnote 9 of the Bryant opinion is that this court indicated that it is factually sensitive, whether it is or is not. And in fact, this court said it hypothesized two things that could be considered important in deciding whether something is or is not, in a fall case, is or is not medical malpractice. For example, this court said, the medical condition of the plaintiff or the sophistication required to safely effect the move. Those could impact. Those factual determinations in a particular case could impact a court's decision on whether something is or is not medical malpractice. Factually sensitive. That's what this court ruled. What do we know just about those two things that Chief Justice Markman identified in Bryant? What do we know about the medical condition of the plaintiff? Nothing. We know she suffered a stroke. What was Ms. Trowell's condition as she was escorted, as she was held, going to the bathroom? We don't know. Why? Because they never took her deposition. There was no affidavit filed.
Can I go back to my first order question?
Pardon?
Can I go back to my first order question?
Yes.
Why do I care about evidence if I'm trying to understand allegations? The question is, did the complaint state a claim of ordinary negligence? As a trial judge, I would take out the complaint and read every line of it, and as Justice McCormick suggested, take the allegations as true and in the light most favorable
Correct.
to the plaintiff, and try to decide if it stated a claim for ordinary negligence under C8. I'm not sure why in in Bryant, the case is decided under C7. I'm clutching the opinion now, looking at footnote 9, and I know the opinion also looks at some facts. I'm not sure why it does or why it did. Aren't we just here to talk about the allegations in the complaint to determine whether it states a claim of ordinary negligence or not?
Well, there's two responses to your point. Number one, if it is a C8 motion and there is some question about whether this is or is not ordinary negligence, and quite frankly, I think a drop could fit.
You got a lot of ifs there. Do you think it's a C8 motion or a C7 motion?
Well, it was a C7 and C8, and it could be a C8 precisely because the defendants decided not to provide any extrinsic evidence.
Let me say
and
this.
it's C7
C7
because it was a statute of limitations ultimately.
But only if the court concludes that it's not ordinary negligence.
Okay.
Then you get to part 2,
But then
which is...
then the response comes, if it's a C8 motion, allow the plaintiff to amend, which the trial court didn't do. Allow the plaintiff to amend.
We're not there yet. You're swinging wildly now. I'm asking you the question, which is, aren't I looking at this? So you agree or disagree? Or you refuse to take
It
a
is
position?
completely based on the complaint because that's the only thing we have in this case.
See, I read the Court of Appeals opinion as assessing the facts sort of in the way that the Bryant opinion invites the court to do, to look at the facts, and the Court of Appeals then concludes in this case that we have to, further factual development is required to properly ascertain whether plaintiff's claims in the complaint sounded in medical malpractice or ordinary negligence. That seems like a very strange conclusion to me. It makes me cross-eyed. I have to look at the facts to understand what's in the complaint.
Well,
the complaint is filed at the beginning of the case.
No, because here's what's in the complaint that the defendant never wants to talk about. Look at paragraph 8 of the complaint.
Got it, right
We are
here.
dealing with a case that's now in the Supreme Court of Michigan, and we're dealing with 20 paragraphs. That's all. Not one other piece of evidence. What does paragraph 8 of the complaint say? Defendant hospital has a duty to ensure that plaintiff received proper assistance while a patient, including assistance ambulating to and from the bathroom while she was in the ICU. Why is that not that duty? Why does that not present the three questions, the three issues that the Court of Appeals addressed in this case? That's what it says. Okay, is this complaint a
Model 30.
fantastic piece of pleading? No, it's not. The fact is, though, that there was nothing ever to explain what was in the complaint. And the fact is, it's there. They had a duty. They had a duty to provide assistance.
I mean, part of the problem was there was an attempt to amend the complaint. I mean, to the extent the complaint is not sufficient, I'm not saying I have that view or not, but to the extent it was not sufficient, the attempt at amending the complaint made it less sufficient, not more, right? If it didn't have enough facts alleged to show...
I can tell you this. If you reverse on the grounds that she should have been given the opportunity to amend the complaint, there will be a much better amended complaint filed.
Second bite of the apple. I see.
But the fact is, getting down to it, what Bryant really teaches in terms of footnote 9 is that these determinations...
But you can plead facts. I mean, I don't know why we're talking about evidence. You can plead facts, right? You can plead them. You can plead this happened, that happened, the other thing happened, right? We don't need to find out evidence to determine whether the facts that are pled are sufficient to state a claim. I mean, you're making me crazy. This is, as trial judges, you sharpen your pencil and you do this all day long when somebody brings a C8 motion, right?
Okay, but the fact is that what the Court of Appeals ruled in this case is we can't determine, at least those first two, issues that the Court of Appeals addressed in the case. We can't determine if those two issues are, in fact, malpractice or ordinary negligence. Why? Because we don't have the facts. That's all the Court of Appeals said in this case.
But aren't those two different, that's merging the two questions, right? The first question, does the complaint state a claim? The second question is, does the party have the evidence that they need to prove the claim? Right? Those are two different questions.
That's correct.
You can't merge them together.
And the defendant has raised the question about whether the allegations in the complaint are in fact medical malpractice or ordinary negligence without any evidence to assess that question.
The only way to interpret, isn't the only way to interpret the motion of the defendants here is that they're saying the complaint does not state a claim for ordinary negligence? Isn't that the only way to interpret the legal issue before the court?
And if that's true, we are at the Supreme Court.
You keep saying you answer my questions with if. I don't understand those. Is it true or is it not true?
Well, I assume, in light of the fact that they attach not one piece, not one document, that must have been their claim. And in fact, if you read their motion carefully.
I mean, I would suggest to you that's the same claim in Bryant or any other case where we're called upon to decide whether there's malpractice or ordinary negligence. We're looking at whether the complaint alleges a claim for malpractice or ordinary negligence.
I can tell you from handling lots and lots of post-Bryant cases, every one of them that I've ever handled is fact-intensive. Every single one of them. There are lots of depositions to read. There are lots of documents to read. That's a Bryant motion.
I'm not sure I understand Justice Viviano. But I feel like you guys might be talking past each other, or maybe we should let you speak a little longer. But I think maybe Justice Viviano is asking a sort of easier question, Mr. Gonzato, which is, if given what the burden is and the standards are and what the motion must mean, why isn't it enough? Why shouldn't the Court of Appeals just have said the complaint is sufficient? There's this second fall. Like, why do we have to say we don't know enough facts to determine the question? It's a weird thing to say, isn't it?
The fact is, when the case got to the Court of Appeals, there was, in fact, I think, a proper discussion, a better discussion of Bryant, okay? And I think the Court of Appeals was correct in saying that there has to be factual development, and it's
sure there does in every case. If you're going to decide a C-10 motion at the end of discovery or toward the end of discovery, and whether there's a fact issue, you can lose twice, right? You can lose on the pleading, or you can lose at the end of discovery.
I can say this, that if the trial court, and by the way, the trial court, if you read the trial court's opinion in this case, the trial court's opinion is not a full order of summary disposition. The trial court rules that there was, that the issue of staffing is not ordinary negligence, that training is not ordinary negligence, and that patient monitoring is not ordinary negligence. That's all the trial court ruled. What's completely absent from the trial court's ruling in this case is dropping.
And second dropping. So why couldn't
the first as well.
All right.
There was nothing about the first.
So why couldn't the Court of Appeals just said the trial court's reversed? It didn't address the allegation in the complaint, which we have to assume is true, in a light most favorable to people, that the patient was dropped a second time. That might well be negligence. See Bryant, done. Why does it say we need more facts to figure out? It's almost like a half win for your client.
If you need more, I guess my alternative argument to what the Court of Appeals should have done then is the Court of Appeals should have reversed the denial of the motion to amend.
And stop
because
talking.
you have a C-8 motion, and the C-8 motion was, if it's decided solely on this pleading.
It's complicated by the fact that the lawyer, whoever it was, didn't get the hint, right?
Well, the fact is that the trial court still denied the motion to amend. Okay.
Well, because the pleading didn't meet the shortcoming in the
amended pleading's not very good either.
Yeah, that's what I mean.
Well, the motion was still denied
because the amended pleading wasn't very good.
Well, the fact is that there's still paragraph 8. There's still paragraph 8 in this complaint. Paragraph 8 does, in fact, talk about the duties.
So that singular paragraph is enough to save the whole case.
I'm sorry.
That single paragraph saves the case.
Well, you know, a lot of cases are saved by a single paragraph when the entire record is 20 paragraphs long. The entire circuit court record is 20 paragraphs long. I should think that this case can be saved by one paragraph in light of the fact that they'd elected to file a motion based solely on the pleadings.
But the case was in plaintiff's hands all along as to what to plead, whether it was 20 paragraphs or 40 paragraphs, whether to call it negligence or medical negligence, whatever they called it. It was all in plaintiff's hands.
And it has an allegation that a nurse's aide dropped a patient. Undeniable. Dropped a patient. And it has an allegation that they had a duty to accompany her when she was going to the bathroom. Now, if this case is about anything, it's about Trick and it's about Maiden. There's those two cases from this court which Justice McCormick cited correctly, because what the standard is in this state is that everything in a complaint on a C-8 motion is to be construed in the light most favorable to the plaintiff. If that's what this case has gotten all the way to the Supreme Court about, that's what this case is about, Trick and Maiden.
One question for you. From all of the trial judges who are on the Court of Appeals, which I guess is this half of the bench, trial judge looks at the complaint, says it's not pleading negligence, and we look at it and it's far from clear. They bring a motion to amend. Let me see what it says in the amendment. It's still far from clear. Trial judge says, no, I'm sorry, you lose. I'm granting the motion. How do we conclude the trial judge abused its discretion?
Your question has answered itself. If it's far from clear, then you construe it in the light most favorable to the plaintiff.
So do you keep going until it's granted? How many times do you have to give them another opportunity to state more in their complaint?
Look, what's in this complaint is a nurse's aide dropped somebody who had a stroke. Dropped somebody, okay? Now, I can tell you from handling a lot of cases post-Bryant, that's pretty close to the line already, crossing ordinary negligence into ordinary negligence. Somebody drops a patient. Now, you construe this in the light most favorable to the plaintiff, particularly when the plaintiff has alleged that they owed a duty.
Okay. So the abuse of discretion in failing to allow the amendment is the trial court should have read through the other 19 paragraphs and found the negligence paragraph.
No, that's the secondary argument, because the first argument is directly from what I read you before in Bryant, and that is a transfer injury. Somebody who falls may or may not be professional negligence. That's what this court ruled. Now, when you have that ruling from this court in footnote 9 of the Bryant case, and you have no facts as to how this accident happened, how can a circuit court decide the motion for summary disposition based solely on the pleadings? This court has declared in Bryant it may or may not be. You know nothing about the condition of the plaintiff. You know nothing about the expertise it takes to transfer that person to the bathroom. Nothing about the facts. And this court has already said it may or may not be. That's what the circuit court should have reacted to. And it should have denied the motion. Or, secondarily, it should have allowed an amendment if it thought that there wasn't enough in this complaint.
Always a pleasure to see you in court.
Pardon me?
It's always a pleasure to see you in court.
Thank you. Always a pleasure to be here.
Thank you, counsel. Case is submitted.